Refresh Franchising, the heroic choice for entrepreneurs. Proud sponsor of the Distilled Wisdom podcast.
We're going to talk franchise law.
Canada is an interesting market to expand into because most of the same things that are required to be disclosed in the U.S. are also required to be disclosed in Canada. As you know, there are a great number of franchisees who often don't read the FDD in the first place.
Just making sure the cops aren't going to, come knocking at your door.
Yeah, the franchise
right?
police, exactly, yeah. And in Canada, everything has to be delivered in one document at one time.
This one's important for franchisors listening, that they pay attention to this section. I thought it was fascinating. All right, welcome back to another episode of Distilled Wisdom. I'm Adam Ferracane, your host. You already know that if you've been here before. We're going to mix it up a little bit. I've had franchisors, suppliers, franchisees, a little bit of everything on the show. This is going to be a first with an attorney to mix things. We're going to hope to help some franchisors move into the Canada market. So we have Chad Finkelstein. See, look at that, guys. I didn't mess up the name that time. He's with Dale Lessman out of Canada. You're in the Toronto area?
Yeah, we're in
right?
Toronto. Yeah.
Okay.
Yeah.
Well, welcome to the show.
Thank you. Thank you for having me.
It's a pleasure, man. So normally we do more interview style, but today we're gonna talk franchise law.
Yeah.
Which is everybody's, favorite subject, is talking about, the legal ramifications of business, right?
Yeah. Everyone wants to hear from the attorney.
Of course. Now, actually, it's extremely valuable. So I expect this episode for franchisors to be popular, right?
Okay. I'll do my best.
All right. So tell me a little bit, Chad, about your firm and a little bit about what you guys do and, your specialty in law.
Sure. Well, the firm is a 25 attorney full service firm in Toronto, which is the largest, most populous city in Canada. Our franchise department is, I think, one of the larger franchise legal departments in Canada. And I think we try to operate as a bit of an outsourced in-house legal department for most of our franchisor clients. So we certainly help them with getting all their whether they are domestic franchisors within Canada, helping to support their franchise sales and development programs, or those who are entering Canada from foreign markets, most often the U.S. We work with them, and we certainly help them with all their franchise legal compliance and all their brand protection. And then we're basically there as outsourced general counsel to handle as much of their legal support as we can. FDDs are only one part of it, fortunately.
So I'm curious just in myself, because I'm a franchisor.
Yeah.
And I'm not looking at Canada yet.
Yeah.
But what would be some main considerations for somebody coming from the U.S. and then going into Canada? Do we have to register by its Providence is up there?
Province, yeah. There's no registration in Canada.
Okay.
There are no regulators at a provincial level or a federal level. So your FDD is basically ready to go when your franchise lawyer tells you that it's ready to go.
That sounds much easier than the United States.
Yeah. The barrier to entry is a lot lower. So you don't have to deal with any of that. There's some flip sides to that, and there's some, unique particularities about Canada. Canada is, an interesting market to expand into because it's so proximate to the U.S., obviously. And you're in the part of the northern U.S. So, there's parts of Canada that are closer to you than parts of the U.S. are. And so, culturally, it feels like it's in many ways just sort of an extension of the U.S.
Right.
Oftentimes as well. Maybe a little less these days.
Do you think franchisors see it like that? Like almost, viewing it like the next state they're going into? Right?
Depending on their state. Yeah.
Right.
Those who are in, I think, the northern U.S. will often see it because they have so much experience, often just traveling personally into, some of those, I guess, sort of border cities that may border against their state. So I think there are a great number of U.S. franchisors who do view it as a very natural extension. And the travel's not too onerous. And so it feels very accessible for most parts of Canada. It's a bit of a strange country though, because it's enormous, right? The geographic landmass is enormous. It's second largest country in the world behind Russia. But it's very sparsely populated. Across that enormous, mass of land, there are fewer people than there are in all of California, by like several million.
Yep.
And they are, we have a small number of densely populated urban areas.
There's essentially three primaries, right?
There's Toronto, there's Vancouver, there's Montreal, and Montreal is sort of on its own island of law because it's within the province of Quebec, which has a completely different legal system than the rest of the country.
Okay.
And there's Calgary, Alberta, and then some smaller cities, Ottawa and Edmonton and Winnipeg. And then for the most part, you have chunks of, a lot of vastness in between that are not really all that populated, and many and smaller, very small cities and small towns. And they're all kind of scattered across the country. There's not many. It's not in the same thing as you could be in the northeastern U.S. and you've got New York and Philadelphia and Washington, and Chicago's even not that far over, and Detroit, and they're all relatively close to each other with many small cities in between.
Sure.
Most of Canada is not like that, which does mean that for a U.S. franchisor, it feels like it's a natural extension. It feels like it's an easy step and not really entering a true international market. But it's a different degree of support when you're talking about crisscrossing that entire landmass and with very little in between. So it always leads to interesting discussions about whether you should be expanding to Canada by way of single unit franchising, or whether area development makes sense, or, oftentimes it's by master franchising. But master franchising, again, you're giving somebody this enormous territory where your master franchisee is going to incur a considerable amount of cost to be able to crisscross and travel the country to support franchisees everywhere.
So you're probably way more well versed on this than I am. But when we talk about like doing a master, I always considered that like down the line if I went to Europe or something.
Yeah.
It wouldn't even cross my mind when I'm looking at Canada, right?
Yeah.
Do a lot of people do it that way, though?
There's a great number of, I don't know that I would say most, but there are certainly many U.S. franchisors who identify master franchisee for all of Canada or parts of Canada. There's a big difference between Eastern Canada and Western Canada. And so we sometimes see that, someone will get Eastern Canada, someone will get Western Canada, someone might get the province of Quebec. As a master franchisee, it depends on the franchisor really. If the franchisor would say the U.S. franchisor had no real plans to expand into Canada, and somebody from Canada approach them, and especially somebody who is well capitalized and has experience in operations or experience in franchising, that's oftentimes a very good candidate. And for the U.S. franchisor to say, this isn't my market.
Sure.
There is this unique sort of, there's this unique kind of juxtaposition of huge landmass, small population. If you know that market, if that's that's what best, that's where you are, then I'm just as happy to have you own the territory and run with it. I would say that with the U.S. franchisors we work with, I'd had to ballpark maybe somewhere around 25-30% end up granting master franchise rights for the whole country.
Okay. I mean, what you said makes perfect sense. If they don't essentially want to deal with it and they don't want to, do the research and the homework into the market, that does make perfect sense.
Yeah. So we do see a lot of it. And going back to your original question about selling franchises in Canada, we do have a lot of those same rules that you have here. Nothing signed, nothing paid for at least 14 days until someone gets an FDD.
So that surprised me now, too, because you don't have the registry, and it sounded really lax. That was one of the next questions I was going to ask is so if I get an inquiry out of Canada, which, I'm not looking at it now, but say it's a year from now, and somebody inquires out of Quebec or Toronto, can I open that conversation? There's nothing special I need to do. I can go move forward with the conversation, right?
You can start a conversation for sure. First of all, it's no secret that, of course, FDDs are publicly available in the U.S.
Right.
So any Canadian prospective franchisee could go and look that up and see what you're offering in the U.S. So you can start a conversation on that basis. In Canada, we don't have any federal franchise law. There are 6 provinces that have franchise law. The other provinces don't. And so a lot of these rules and laws just don't apply at all. And if you were in the province of Saskatchewan, for example, they don't currently have franchise law. If you're in the province of Nova Scotia, you could meet somebody today, get an agreement signed today, get a fee paid today, never have to give them an FDD. In British Columbia, Alberta, Manitoba, Ontario, Prince Edward Island, and New Brunswick, these laws do exist. And so you can start a conversation as long as, I guess, 2 things. Number one, everything that you say should be consistent with what is ultimately in the FDD. Mm-hmm. So if someone asks you a question about what the fees are in Canada and you don't yet know, probably a good idea to wait to give them that information until you're certain. And number 2 is that in Canada, everything has to be delivered in one document at one time. So sometimes you'll see that a franchisor or a U.S. franchisor, they might offer some historic sales information for a Canadian franchisee to consider. And then they say, if you're interested, let us know, and then we'll give you the FDD. There's no law that prohibits you from providing that sales information or those, the FPRs, financial performance representations. No law prohibits you from doing it, but it has to go in the FDD as one document at one time. You can't have sort of piecemeal disclosure, and that would include FPRs.
I think that's similar in the U.S. too, isn't it?
Yeah.
Yeah. Again, not an attorney, but from my understanding of it. Yeah.
Yeah. And so, but you often find that salespeople will sometimes have separate discussions. Sometimes.
I got you. So we'll give you this piece of it now, that piece.
Yeah.
It's relevant.
That's right. And so we'll do an FDD for a franchisor, and then subsequently we'll find out that in fact, we gave them our business plan for them to take a look at it. We showed them our US item 19. Okay. Well, we now we have to put that in the FDD because we just made an FPR.
So it's not a big mistake. You just have to add it in when you give it to them.
Yeah, that's right. Yeah, so, just include it with all the same qualifications and disclaimers. I mean, slightly different ones.
Just making sure the cops aren't going to, come knocking at your door.
Yeah, the franchise police.
Right?
Exactly. Yeah.
Okay.
Yeah. So no registration, no renewals, no annual filings, nothing like that. There are a few things that are uniquely different about the FDD. And so one of the things is that, sure, you don't have to do renewals, you don't have to do filings, but the FDD that you give has to be current and in many cases particular to that prospective franchisee. If you've got details about their specific offering, their location, their territory, the FDD may have to be prepared on a bit of a bespoke basis.
And is that across all provinces? Or?
Yeah.
Okay.
Yeah.
That they're trying to actually do that here in the U.S. more. I was in D.C. advocating for the NLRB's rule.
Yeah.
And that was one of the subjects they talked about a little bit at the conference is, we actually are pushing more to get a regular template of how it should be outlined in the U.S. too, so that it's structured the same no matter what franchise you're looking at.
Yeah.
Even though, from what I've seen, most franchises already do that. Right, they all have the same structure and they're already templated in it. So I don't know why they were pushing it that much because I can't imagine there's too many cowboys out there doing it.
No, I guess the policy objective in Canada is, given that the policy objective of an FDD in the first place is to help you make an informed decision. Right. The way that's been interpreted by courts in Canada is, well, how could you make an informed decision if you didn't have all the information relevant and specific to you? So what we know, for example, is you're a brick and mortar franchisor, restaurants or retail store. And you have, you're subletting the premises to a franchisee, or you've negotiated the lease on their behalf and then handed it to them to sign. Those are material details, material facts that must be disclosed to the franchisee, because how could they bind themselves to a franchise agreement without having been disclosed about the actual lease that they're going to be committed to?
So my question there would be, does that slow down the closing process, right? Especially you're talking brick and mortar. I don't know brick and mortar.
Right.
If you're talking brick and mortar, that means that before you can essentially have them sign, you have to have the whole location sourced and position.
In some cases. So it depends. It's all very, fact specific. If in the case of a brick and mortar franchisee or franchisor and franchisee, for example, if the franchisee is responsible for going out and finding locations, franchisor is there to approve it, right? To review it and approve it. Well, I don't really have anything as a franchisor to disclose to you. Then it is included, right? Because but if I found the site, or if I am subletting the site to you, or if I negotiated the lease on your behalf and then put it in front of you.
McDonald's, right?
Maybe, yeah. I mean, if I've got site-specific details in my knowledge, in my possession, that you are, you're not sure about, you weren't aware of, you wouldn't have been aware unless I told you, that might be the sort of thing that has to be disclosed. Oftentimes, the same could be true of like a development schedule, right? So if you are, and this is not really tested by any Canadian court, but if you've got a multi-unit franchisee and you want to put them on a development schedule to open a certain number of units by a certain date, it's a pretty material fact, right? To know what your territory is, to know by, especially if your fees, and your fees are going to be tied to meeting certain development milestones. So that's the sort of thing that might have to be disclosed on a bit of an individualized basis.
Okay.
Yeah. So it can slow the process down. There's ways that franchisors can certainly help themselves to, so that way they can sign franchise agreements even without locations or territories in mind, for example. One of the ways that a franchisor can do that in Canada, and this is not always the most popular solution, but if you give a franchisee an option to terminate the franchise agreement within 6 months, 9 months, a year, whatever it is, if by that point in time we haven't yet agreed on a site or agreed on a territory, then, I can't therefore impose it on you because you have to agree to it with me.
Right.
And then if you can walk away without any risk of loss, then, I don't have to worry that I didn't give you all the information up front because I didn't have it on that day, but I don't want to slow down my sales process.
Stay with us. We'll be right back.
Citizens of Distilled Wisdom, gather around and listen up. If you're a fan of the show and want to join forces with its host, Adam Ferracane, then Refresh Franchising is the perfect choice for you. So gather your courage, summon your inner superhero, and visit refreshfranchising.com to launch your heroic franchise journey. Refresh Franchising, the heroic choice for entrepreneurs, proud sponsor of the Distilled Wisdom podcast.
Yeah, I don't think there would. Again, I'm looking at it from a franchisor perspective. I see the risk in that, but at the same time, if you're vetting the right partners, then it shouldn't be a problem.
That's right. It isn't a problem until it becomes a problem. Yeah.
Well, we don't need lawyers. We need a lawyer, right? It's the way of the world. What are some of the differences between the provinces? Are there like drastic differences in some of the franchise laws? Because like you said, they all have their own kind of, set of laws. Are there some that are really stringent on certain things or
fortunately, they aren't terribly different. Okay. The one exception would be Quebec, which is probably...
you put an emphasis on that.
Yeah. So the province of Quebec operates under a completely different legal system than the rest of Canada and all the United States does. We all operate under what's called a common law legal system that's based on the UK model.
Yep.
In Quebec, they operate under the from France model of law, a legal system called civil law. So the laws are interpreted and applied in a different way than they are in the rest of the country.
What are some of those differences? Now I'm just curious about structure.
So one of the ways is that oftentimes the legislation is the legislation in Quebec is intended to tell you this is the way this is what the law is. This is what the rules, this is what the requirement is. And the role of the court in interpreting that law on a sort of a case by case, less frequently the way it happens in Quebec. So the law is this, therefore it applies to this situation, sort of full stop. So
in other words, arguing like former case law and stuff would.
Yeah, that's right. So it's a more rigid form of interpretation, an application of the law than it is in the other provinces. And also French legislation, Quebec legislation is also in and of itself just different than a lot of the customs and conventions that we have in common law jurisdictions for the way we sort of transact business. So for example, in Quebec, they don't have any franchise law. There's no legislation that exists. What they do have are laws about contracts of what they call adhesion. A contract of adhesion, you're adhered to it. Right? Yep. One party sets all the terms, the other party doesn't get a say in it. They're unilaterally imposed on them. And so not all franchise agreements are necessarily a contract of adhesion. It depends on a few things, including did the franchisee have an opportunity to negotiate? Because if they did, then it's not a contract of adhesion. If you are a contract of adhesion, there's certain laws relating to pre-contractual disclosure, relating to French translation of the contract, that, if you're a contract of adhesion, these all apply to you. If you are not, then they may not apply in the same way.
So my first question would be, does your FDD change just for Quebec? Do they have a different version?
No, because all they really say in Quebec is that some measure of pre-contractual disclosure is required without any detail. There's no 14-day rule or anything like that. So what we know, the practice of most Canadian franchise lawyers has always been to say, well, if my FDD is good enough everywhere else, surely it's got to be good enough in Quebec. So what most franchisors will do is just say, here's my FDD. And if they don't yet have one for Canada, because Quebec is the first market they're expanding into, okay, then here's my US FDD. I've not adapted it for your market because I didn't need to. Unlike the other provinces where you have to have an Ontario FDD, an Alberta FDD. And the rules between those provinces are all pretty uniform. What most Canadian lawyers will do is come up with a Canada-wide FDD that you can use in any one of those provinces.
So next question on that is, I have a U.S. FDD.
Yeah.
How heavy is the lifting of converting it to a document for Canada?
Yeah.
Right? Is it heavily involved? Is it major differences, or is it really just tweaking a few things in it?
It's somewhere in between. Most of the same things that are required to be disclosed in the U.S. are also required to be disclosed in Canada. There's a few things we have in addition. There's a few things that we don't have that are required in the U.S. And then there are a few unique local considerations relating to things like governing law, dispute resolution, currency, taxes that have to be sort of, Canadianized. So, yeah, almost nothing is going to seem foreign to a U.S. franchisor. Almost all of it is version of what a U.S. franchisor would already know.
Okay.
Yeah.
Do they require financial disclosure?
Yeah.
Oh, yeah. In the
financial
U.S.,
statements,
it's optional, right? With the item 19. Yeah.
Oh, sorry. That's optional. Pardon
Yeah.
me. Yes, that's
It is
optional.
optional?
Yeah. I thought you meant financial statements. Item 19 is similarly optional in Canada.
Okay.
Yeah. We do have this one very unique technicality in Canada. Almost every franchisor lawyer hates. Every franchisor hates. It is completely a technicality, and it trips up a great number of franchisors, especially from the U.S., who have no real equivalent of this at all in the U.S. So we have this unique, bizarre requirement that the FTD has to be certified, meaning that any two directors and officers of the franchisor have to, in their personal capacities, sign a document which says everything that is in here is true and accurate and valid, and franchisee, you can rely on it. That's it. It's like 2 sentences long. Put your name on it.
I'm looking at it like from a legal lens. They're essentially attaching them as an individual, so removing the corporate shield.
Right. So that's right. So number one, if there are misrepresentations or errors that are in the FDD, those individuals can be personally liable.
Yeah.
And number two, courts have said invariably, time and time again in Canada, that if that certificate, this very short page, if it doesn't get certified, doesn't get signed, it's like nobody at the franchisor, executive level was prepared to put their names behind it and stand behind it. And so if you're not prepared to do that, well, franchisee, how can you be expected to rely
Well,
on
I
it
see
all?
the transparency with it. It's just very unique because the U.S. it protects individuals through the corporate model, pretty well.
Well, that's right. And so an unsigned certificate, just this unsigned page, invalidates the entire FDD. Franchisee gets a get out of jail free card just based on that. It's incredibly frustrating. It's entirely a technicality because you could have a pristine FDD, a franchisee who fully knew and understood what they were getting themselves into. Right? They fully understood the opportunity, had every chance to, review and due diligence, and they had full disclosure. And then somebody forgot to put their names on this one page. The entire thing is invalidated. It puts franchisors in a bit of an uncomfortable position, sometimes an often costly one. They've got to look into whether they need, director and officer liability insurance when they start putting their names on these things. And so it has some impact on the franchise sales process.
Well, any franchisors out there, you got to make sure that that's included in your signing process, whether it's DocuSign or whatever you're using for
That's
it.
right.
Make sure that that's automated in your process and you won't have a problem.
Yeah. And in fact, the first time it ever came up in a case in Canada, it was a hotel franchisee.
Mm.
So, hotel franchisees are, fairly sophisticated, fairly well capitalized.
Yep.
So they got a, pristine FDD. It was uncertified. And basically when the franchisee went to sue the franchisor for damages for an invalid FDD, the franchisee basically said, I forget the exact words, so I'm paraphrasing, I know I'm relying on a technicality here, but I get to, right? Yes, you get to. I personally, I hate the certificate requirement. I resent the policy objective. Most franchisees, I shouldn't say most, as you know, there are a great number of franchisees who often don't read the FDD in the first place. And so to have it all get undone because of a document not being signed that they didn't even care about in the first place, to me, that's a law that ought to be repealed. But so many courts have stood behind this certificate requirement for so long that I don't expect that's ever going to happen. So it just remains a warning sign about doing business in Canada.
I see the motives on them not wanting to do it from the outside looking in, for them, they're making them stand behind what they're having people sign. So,
yeah. So, but personally.
So you were referred for the podcast.
Yeah.
And Dan made a suggestion on something we have to talk about.
Yeah.
And that's the trademark protection in Canada. And this one's important for franchisors listening, that they pay attention to this section. I thought it was fascinating. Can you speak a little bit about what's going on with the trademark laws and everything in Canada right now?
Yeah. So trademark law in Canada is fairly similar to what it is in the US. Okay, governed at a federal level, same sort of process to get a trademark applied for. You get it registered, it's protected federally. We don't have a primary and secondary register, just the one. So a lot of the concepts are very similar to US companies trying to protect their trademarks in Canada. The biggest difference is that in the US and in Canada up until 2018, as any franchisor would know who's applied for a trademark, you can go through the whole process, the examination process with the USPTO, and then at the end of the line, once you've been approved, the USPTO asks you for proof of use of your trademark, right? A specimen of use. Yep. So that way nobody is just like squatting on these trademarks indefinitely with no intention of ever using them. And until you submit proof of use, you don't get the trademark registered. Proof that you're using the actual trademark. Canada repealed the use requirement in 2018. So what that means is that in order to get a trademark registered in Canada, all that needs to happen is that the Trademarks Office, the Canadian Intellectual Property Office, CIPO just needs to have approved it because there's nothing out there that's too similar. It's not the trademark's not too descriptive. So they're still doing
that check.
They still do the examination to make sure the trademark is registrable compared to, other similar trademarks that may be out there. But once you've cleared that hurdle, then you move straight to registration. There's no requirement to ever prove that you've used the trademark. When this law change was introduced in 2018, Canadian lawyers were screaming from mountaintops that this is just going to encourage trademark squatting, right? Yep. Just like cyber squatting, where somebody, domain name squatting, where somebody, picks up your domain name or the trademark that you want and basically holds it for ransom from you. And we've seen that start to happen. That there are Canadians who recognize that there are U.S. companies that have not taken steps to file or protect their trademarks in Canada. And they do go and they file those trademarks and then effectively get to hold them for ransom because they just got it registered.
They own the trademark.
They own the trademark. It got all the way through, got registered, and now that is a major obstacle. And this is different from when, somebody else coincidentally has the same trademark as you and they're actually using it. That's a different hassle, and that happens in the U.S. and Canada equally. But this is a uniquely Canadian issue and challenge for U.S. companies, is that there are enterprising Canadians. And we're normally a very humble, very polite bunch, but there are a small number of enterprising scammers among us who see an opportunity to grab your trademark, hold on to it, get it registered. No one's ever going to ask at the examination level whether you intend to use the trademark or not. And then you got to deal with that person.
Is there any recourse? So let's say I'm a brand in the United States. Somebody has my trademark. I find this out when I try to go into Canada. Do they have any recourse, or do they just have to?
They can. Yeah. There's a few different channels that are available. First of all, when the use requirement was repealed, the trademarks legislation in Canada was amended to introduce this concept of bad faith filing. So if you can prove that somebody filed for your trademark in bad faith, then you can get their trademark canceled. And how do you prove bad faith? This is sort of
question.
It's sort of a developing area of law because it's relatively new, right? It was introduced in 2018. So now in 2024, we're starting to see over the last couple of years some of the very first cases that are analyzing it. One thing that we know is that, certainly if there's evidence that
if they're not using it, it shouldn't be that complicated. But when we start getting into law, things always get muddy.
Yeah, so
a rational person thinks X, Y, Z,
right?
But then you go into a legal setting, and it's like, well, a logical person would agree with X, Y, Z.
Yes.
However, there's this, and this to consider in case law or whatever.
Yeah, that's right. So one thing we know is let's say you want to file for your trademark in Canada, and I've already got yours registered. If there's proof that I offered to sell it to you, that's proof of bad faith, that I clearly got it with a design to extract it from you in exchange for money.
Well, if that's proof in and of itself, what are they doing with them? Are they just hoping people buy them and without challenge?
Oftentimes, yeah, that happens, yeah. Just like domain name or cyber squatting for sure. There can be proof of it where, let's say I am a prospective franchisee of yours in Canada, right? You and I have had a few discussions about whether I'm going to buy a refresh.
And then they go out and they just trademark.
Right.
Use your name.
Right. And so that's probably going to be evidence of bad faith. That wasn't a coincidence that I chose the same name as yours.
Right.
I went out with a view to usurp your trademark ownership in Canada. So it's a very fact-specific, case-by-case determination of whether someone's applied in bad faith or not. The other ways that a U.S. franchisor can sometimes counter that is if they can show that they have got it's called acquired distinctiveness of their trademark in Canada already. So if a U.S. franchisor, brand owner, not just a franchisor, can prove, okay, fine, my trademark might not be registered in Canada, but Canadians know me, right? Like Canadians know the brand, and I have proof of that because I've got all these Canadians who are members of our loyalty program. I have shown up at all these different Canadian franchise trade shows, trying in earnest to sell franchises in Canada. I have got all of this proof of Canadians who engage with us on social media, even though we have no locations in Canada. These are examples of things that can all go to show the trademark took on its own certain, recognition, and it is distinct in the minds of Canadians, and that gives it rights that ought to leapfrog this, basically fraudulent trademark application in the first place.
What are you seeing out of the first cases? Are generally the brand winning in these cases, or?
It's it really does depend. It depends on the strength of the brand. It depends on the facts. We had a case. This is not in the sort of realm of bad faith, but there's a case a few years ago where Hilton Hotels had filed for the trademark Waldorf Astoria.
Okay.
And somebody tried to get it canceled on the basis that Waldorf Astoria, there are no Waldorf Astoria hotels anywhere in Canada, so the trademark can't possibly be in use. Hilton was able to successfully maintain its Waldorf Astoria trademark in Canada on the basis that Canadians are still using the trademark, engaging with the trademark. What's the proof? I'm sitting here in Toronto and I go and I make a hotel reservation for Waldorf Astoria in the US. I've used the trademark. I've engaged and interacted with the trademark. So that wasn't in the realm of sort of bad faith filings, but when you are a brand owner, a franchisor, and you can show that you've got Canadians who know you, engage with you, done more than just existing, but you've actually like Canadian. I gave the example about loyalty programs. When you've got Canadians sitting in Canada who are engaging with your trademark, even though there's no physical locations, that's going to be stronger evidence of your acquired distinctiveness in Canada, which should defeat some of these bad faith actors. And like I said, the demands for money, ransom, right? That can make a difference. And so in the cases that we've seen, that was clear. And the court decided in favor of the rightful brand owner because there was evidence that somebody had clearly applied for it just to extract some settlement out of it.
I have a real life scenario when it comes to trademarks that happened to me.
Yeah.
I had a competitor get angry at me, and he got upset because my managers, I guess, approached some of his people trying to, recruit him. Right. And so he got really upset about it, got emotional. And he looked at the state level if I had registered trade names for all of my brands, right? And I hadn't, which was a mistake on my part, but I did have federal trademarks on it.
Yeah.
Right? So he went and he tried to essentially register the names and take the names of all my brands and then sends me a cease and desist order. Like, what a childish move.
Yes. Almost the exact same thing.
But I mean, it was literally just one letter back. It's like, cool. Well, now you're infringing on my federal trademark.
Yeah. Yes. Right. Yeah. He didn't think that one all the way through.
He didn't check. He didn't go to the federal level probably.
Yeah. Yeah. I think I made a mistake earlier. I think I said primary and secondary register. I meant to say primary and supplementary register.
Okay.
But that's almost, it's in spirit, that's almost the exact same thing. Right, which is that I'm very clearly not the person who is entitled to use of this trademark. And we've seen it happen. I mean, we've seen it happen that there is a popular U.S. brand and there is somebody in Canada who, and you can see the date they filed, right, 2019, 2020. And then you can see that they've got no restaurant or store in Canada yet. It's pretty clear that it have gone all those years.
It shouldn't be hard to prove brand recognition if with any sizable operation to Canadians, right?
Right.
So your example with Hilton, I mean, any sizable brand, like Canadians know about it in the U.S.
Yeah,
for the most part.
Yeah, so this will be probably the next phase of a lot of these disputes, which will be okay. So I'm an emerging restaurant brand in the U.S. I have no locations in Canada. We're just getting known in the U.S. Now, you have applied for my trademark in Canada. Is it enough that I got this publicity that was seen by Canadians? Is it enough that I had some inquiries from prospective franchisees in Canada? Is it enough that I took the step of preparing a Canadian FDD? Even though I'm not in Canada and even though I'm still getting known everywhere,
right,
is that enough to show that I've got some trademark rights in Canada that clearly should trump what this person did by just filing for my name when it was clear that they had no intention of using it. And so we'll continue to see, but it is, and the other thing I should mention about filing trademarks in Canada is that the Canadian Intellectual Property Office is the most backlogged trademarks office anywhere on the planet. It's not even a close second.
Is that why they did this?
That's has been the speculation, that they eliminated the use requirement to eliminate the bureaucracy and the paperwork because they were so backlogged. If you apply for a trademark today, I forget if you and I talked about this earlier, if you apply for a trademark today, it will take over 3 years to get your application examined. It'll just sit there in the queue for over 3 years. And so given how long it takes, without sounding self-serving about it, we definitely always recommend to U.S. companies, if you think you're going to be in Canada within the next 3 to 4 years, best to apply for a trademark now. Otherwise, somebody else.
Even if you're unsure, in my eyes, right? If you're unsure and there's a slim chance you're going to be there in 5 years, why not just get it?
Yeah.
Is there a cost to maintaining it anyway?
No, it just sits there in the queue.
Right.
Yeah.
So you might as well. And what do they cost generally? Like, what's the investment to get a trademark?
Well, I can tell you that the CIPO charges filing fees of, I think it's 350 Canadian dollars for an application in a first class. And I think it's $120, $150 for each secondary class. And so that with legal fees for a single class trademark application, who knows? But it shouldn't cost very much.
It's definitely worth just
it should be very, very accessible to file a trademark application in Canada. Recognizing how long they were taking, the Canadian CIPO, the Canadian Intellectual Property Office, they made the decision a couple years ago to introduce some other channels to have your application expedited. And one of them is if you swear an affidavit, which says, I believe my trademark is likely going to be the subject of litigation. So let's say you decide you're going to apply for your trademark in Canada and someone else is already there. Maybe you send a cease and desist letter. I mean, the prospect is out there, litigation. You can swear that affidavit, submit it to CIPO, and your trademark application, which was just filed and was at least 3 years away from getting examined, all of a sudden gets expedited, and within about 2 weeks you can get a response and your examination done. So there's some recognition.
Is there any evidence required to do that, or you just swear on the affidavit?
Well, I guess it would be a sort of...
I love Canadians. Just, I swear, take my word for it.
That's it. Yeah. We're very, very, very trusting people. It's interesting, actually, because we found initially you were able to get these affidavits that they just said, I think this is going to be the subject of litigation. I think CIPO might have been a bit overwhelmed by the number of people who are submitting that. And so now they're slowing down and saying, hang on, you got even more detail than that. Give me something that
all
can be...
All of a sudden, everybody's expedited. What happened?
Yeah, exactly. So there's some description that which you have to be careful with, because what you submit can be a matter of public record. It's all publicly searchable. So if you're in a dispute with somebody, you don't want to over disclose, but you want to disclose just enough that your request is going to get approved. But that is a channel, so that way you're not sitting there in limbo for 3 or more years, not sure what's going to happen when this other person is ahead of you in line and they filed in bad faith. You can use this channel sometimes to expedite your own application.
Make perfect sense.
Yeah.
That's awesome.
Yeah.
Do you have any advice you would pass on to a franchisor or anybody looking at going into Canada that we didn't cover in the episode? Like, what would be your legal advice for them to start the process of going into Canada?
I definitely would certainly start with a trademark application. But I guess I would say that when I think of those situations where we've seen U.S. franchisors really, really struggle the most, I would say to not be guided just by flattery. So if a Canadian calls you up and says, I love what you're doing, I think I could make a go of it in Canada, and I'm prepared to pay you a royalty in order to do it, I wouldn't base your decision to enter into Canada solely based on that. It seems easy. It seems accessible. The cost of a Canadian FDD in the grand scheme of things is, should be accessible for, most any franchisor. It shouldn't be a significant barrier. Yeah. So I would say that you should definitely, you should in some ways almost treat that Canadian like it is another state. And so treat it as it's your home market. I mean, like I said, Canada and the U.S. not that far apart.
Right.
There's a lot of interaction between those two markets. So to not be guided by flattery and say, great, if this all works out, it's an ATM for me. No, not really. I mean, the franchisee is right there and has all the same needs that a U.S. franchisee is going to have. So by all means, start the process when you found the right operator in Canada, expand into Canada because the right operator presented themselves. But I would still proceed with the same deliberation you would for a franchisee anywhere else in the U.S.
Awesome. Awesome. And consider the ramifications of support, right? That's what you were kind of getting at there too.
Yeah, that's right.
Yeah.
Hopefully, all of the pandemic restrictions are all behind us now. But because that introduced a whole host of franchise support issues.
Do you have any feedback on that? I know. During that whole situation, was there challenges for franchisors that are in both the U.S. and Canada with?
There were then, for sure. I mean, there were so many travel restrictions, and if anybody was coming from the U.S., they had to be quarantined initially for a certain amount of time, and oftentimes the training personnel, their own schedules do not permit that quarantine period. So,
weren't there sections where they just weren't letting anyone in, even with the quarantine, or if you had business purposes?
You could get it on business purposes, and you still had to. The quarantine requirements were a little bit intense. So you could still cross the border, but it added quite a lot of time and quite a lot of disruption. So we definitely saw that our U.S. franchisor clients who just prior to the pandemic had signed franchise agreements,
right,
and the franchises are getting ready to open, and there's no one who can be there to help them physically. That was incredibly challenging. Hopefully those days are long.
I hope they all pulled through it well.
Yeah. Unfortunately, not all, but better times ahead, hopefully. Yeah.
So I appreciate you doing the show. Do you want to tell people where they can find you and your firm a little, give you a shout out, website?
Oh, sure. Yeah. The firm is Dale and Lessman. So we're DaleLessman.com, and I'm on LinkedIn, Chad Finkelstein. And happy to talk to anybody anytime.
Awesome.
Yeah.
I appreciate you doing the show, Chad.
Thank you.
Enjoy the rest of the IFA.
Thank you very much. You too.
All right.
I'm Refreshman, and I'm here to empower you to take charge of your destiny. Are you tired of working for someone else? Do you dream of making a difference in your community and unleashing your full potential? Then look no further than Refresh Franchising. With us by your side, you can start your own heroic business venture with the unwavering support and cutting-edge resources you need to conquer your goals. Our franchise model is like a super serum that will give you the strength to succeed. Refresh provides extensive training, ongoing mentorship, and an established brand with a loyal customer base. Plus, you'll become part of a heroic league of entrepreneurs who serve as allies on your journey towards greatness. And the best part, you won't have to waste time building your business from scratch like some kind of neophyte. With Refresh Franchising, you'll hit the ground running at lightning speed and unlock the key to heroic financial success. So gather your courage, summon your inner superhero, and visit refreshfranchising.com to launch your heroic franchise journey. Always remember, together, we can achieve greatness.